name is Catherine McShane. I'm an attorney and the Vice President of Personnel at the McShane firm. You've taken the first important step in handling your criminal case by hiring the McShane firm to represent you, and I'm sure you have a lot of questions about what will happen next. Your first court appearance is called a preliminary hearing. This hearing is held before a magisterial district justice, or an MDJ, and the purpose of this hearing is to determine if there is a prima facie case. In simple terms, this means that the Commonwealth of Pennsylvania, who is represented either by the police officer who arrested you or by the district attorney, must put on sufficient evidence to establish that a crime was probably committed and that you were probably the person who committed that crime. The burden on the Commonwealth to establish a prima facie case is extremely low. So we often use the preliminary hearing as an opportunity to get information about your case and start building a defense. At a preliminary hearing, only the Commonwealth puts on evidence. Though a defendant is allowed to testify and call witnesses, there is no reason for a defendant to do so at a preliminary hearing, except in limited circumstances. The MDJ is not allowed to judge how credible a witness is, and the MDJ must believe the testimony given by the officer, no matter what any other witnesses say. This means that if the officer testifies that it was you who committed the crime, but you get up on the stand and say it wasn't you, even if you have another witness who also says it wasn't you, the judge must believe the officer. This is why we save our defenses for the Court of Common Pleas, or the trial level court, and for a trial where they can actually be heard and matter. It is unlikely that your case will be dismissed at the preliminary hearing, but don't worry. That doesn't mean that you have a bad case or no defense. It is simply a reality when the burden on the Commonwealth is so incredibly low. The preliminary hearing does not exist to determine guilt or innocence. You will not go to jail on the day of your preliminary hearing, even if the MDJ finds in favor of the Commonwealth. In some circumstances, your attorney may be able to negotiate a deal with the district attorney. This would require you to waive your preliminary hearing. Waiving your preliminary hearing means that the officer will not testify and that you agree to have your case bound over to the Court of Common Pleas. A waiver is not a guilty plea, nor does it result in a legally binding plea offer. If you waive your hearing because the district attorney has tentatively offered you a plea, keep in mind that it is still incredibly important to retain your attorney for the common pleas level of court to ensure that your tentative plea negotiation will not be disregarded by the district attorney. It is not possible to cover every possible scenario in this brief video, and everyone's case is unique, so be sure to talk to your attorney so you can understand exactly what will happen at your preliminary hearing.